I inherited 47 acres of forest in Colorado from my grandfather. Not land on paper. Not some forgotten patch of dirt out in the middle of nowhere. Real land, pine trees that were older than most buildings in Denver. A narrow creek that cut through the middle of the property like a silver ribbon. Dirt paths my grandfather and I had cleared with shovels when I was barely tall enough to hold one. To me, that place wasn't property. It was memory. Every summer growing up, my parents would drop me off there for a few weeks. My grandfather, William Flint, lived in a small cabin near the edge of the trees. No Wi-Fi, no television. Just the smell of pine needles and the quiet hum of wind moving through the forest. He used to say, land was the only honest thing left in the world. You take care of it, he told me once while we were repairing a fence line, and it'll take care of you. In 2019, when he passed away, the land came to me. 47 acres, paid off, no loans, no liens, no complications. Just a piece of forest he'd bought back in 1971 for $8,000 cash. Grandpa was a Depression-era man, the kind who kept everything. Every receipt, every note, every document carefully written into leather ledgers that smelled like pipe tobacco and machine oil. When I cleaned out his cabin after the funeral, I found the deed tucked inside one of those ledgers. Inside the folder was a small handwritten note, 5 words. Don't let them take what's yours. At the time, I thought it was just something old men say. I had no idea how serious he meant it. Life got busy after that. I was 47 years old, working as a structural engineer. 70-hour weeks were normal. My divorce had finalized a year earlier. My daughter had just started college, and my son wasn't far behind. Between work, court dates, and tuition bills, driving 3 hours up into the mountains to walk around empty land didn't seem urgent. But there was one thing I never forgot. Every April, like clockwork, I paid the property taxes. $6,400 a year. Not cheap, but manageable. I paid them online, through the county portal. Each time the confirmation email landed in my inbox, I saved it in a folder labeled Flint Property. It felt like keeping a promise. 3 years went by like that. Then, one afternoon in August of 2022, something made me decide to go back. Maybe it was guilt. Maybe it was nostalgia. Or maybe it was the small metal tin sitting on my kitchen counter. Inside that tin were my grandfather's ashes. I'd kept telling myself I would scatter them on the land he loved most. But time kept slipping by. Work always seemed more urgent. That day, I finally cleared my schedule. I grabbed the tin, tossed it into the passenger seat of my truck, and started the drive toward the mountains. The highway climbed slowly out of the city, trading traffic noise for open sky. The air grew cooler as the road wound through hills and patches of forest. The farther I drove, the more memories started creeping back. Fishing in the creek, learning to split wood, Grandpa teaching me how to read a compass. Because, as he put it, phones die, but north doesn't. By the time I turned off Highway 36, I could almost smell the pine trees already. There was an old fire road that led to the property. Nothing fancy. Just a narrow dirt path that twisted through the woods. I'd driven it dozens of times growing up. But as soon as I reached the turnoff, something felt wrong. The road wasn't dirt anymore. It was paved. Fresh asphalt. I slowed the truck, confused. Maybe the county had improved the access road, I thought. That would have been surprising, but not impossible. I kept driving. About half a mile in, the trees started thinning out. That's when I saw it. At first, I didn't understand what I was looking at. Rows of rooftops stretched across the hillside. Bright, stucco walls. Red tile roofs. Perfectly straight streets lined with streetlights. For a moment, my brain tried to convince me I had taken a wrong turn. Maybe I'd ended up in some new development nearby. So I pulled over and checked my GPS. The coordinates blinked back at me. Old Mill Road. Parcel 5593. 2408. My land. I stared through the windshield again. Where my grandfather's forest used to stand, there was now an entire neighborhood. Not a couple houses. Dozens. Identical Mediterranean-style homes with fake balconies and beige paint. Fresh sidewalks. Landscaping crews planting decorative shrubs. I counted slowly as I drove forward. 1 house. 3, 7, 12. The road curved into a wide entrance lined with stone pillars. Mounted between them was a carved sign. Ridgeline Heights, a Whitmore luxury community. My stomach dropped. This wasn't a mistake. Someone had built an entire subdivision on my property. I drove a little farther until a small guard booth appeared beside the road. A security gate blocked the entrance. A man in a reflective vest stepped out of the booth and held up a hand. "Residents only," he said. I rolled down the window. "I'm not visiting," I told him. "I own this land." He looked at me. Then he looked at my truck, an old 2008 Silverado that had seen better days. He smirked. I pulled out my phone and opened the photo I'd taken of the deed years earlier. "This property belonged to William Flint," I said. "He was my grandfather. I inherited it." The guard barely glanced at the screen. "Buddy," he said, leaning against the booth, "people try this kind of thing all the time. You're gonna have to turn around." Before I could argue, a white Range Rover rolled up behind me. The driver's door opened. A woman stepped out. She looked like she had walked straight out of a real estate commercial. Perfect white suit, designer sunglasses, jewelry that probably cost more than my truck. She approached with the calm confidence of someone used to being obeyed. "What's the problem?" she asked the guard. "This guy says he owns the development." The woman slowly turned toward me. Her eyes scanned me from head to toe. Work boots, old jacket, dusty truck. I could almost see the moment she decided exactly who I was. Nobody important. She gave a thin smile. "That's adorable," she said. Then she folded her arms. "Sweetheart," she continued, "if you're looking for construction work, you're a little late. Most of our crews finished weeks ago." I stared at her. "I'm not looking for work," I said. "I'm telling you this is my property." Her smile vanished. She reached into her purse and pulled out her phone, scrolling through something quickly. Then she looked back at me. "Our title company performed a full search," she said. "This land was abandoned." My chest tightened. "It wasn't abandoned," I said. "I paid property taxes every year." She laughed softly. "People say a lot of things when they want money." Then she handed me a business card. "Brian Keir," she said, "our attorney. If you believe you have a claim, you can call him. But I warn you now, it's not going anywhere." "But I'll warn you now, it's not going anywhere." I glanced past the gate again. Families were unloading furniture from moving trucks. Kids were riding scooters along brand new sidewalks. People had already moved in. "How many houses are here?" I asked quietly. 96, she replied. Her voice held a hint of pride. "Most of them already sold." I looked back at her. "For how much?" $485,000 each. My head started spinning. $16 million. She slipped her sunglasses back on wasting our time. She said, "I'd appreciate it if you'd leave." Then she lifted her phone and took a photo of my truck. "Just in case," she added calmly. "In case what?" "In case you decide to come back and cause trouble." She leaned closer to the window. "People like you usually disappear once they realize how this works." Then she stepped back and waved to the guard. "Let him out." The gate stayed closed. I sat there for another moment, staring at the neighborhood that had replaced my grandfather's forest. 96 houses, paved roads, streetlights, families moving into homes they believed were theirs, and every single inch of it stood on land that belonged to me. I turned the truck around slowly and drove away. But one thought kept repeating in my mind the entire drive home. Someone hadn't made a mistake. Someone had done this on purpose. When I left my land that day after discovering the construction site, I kept replaying the scene in my head. The heavy machinery, the survey flags, the workers moving around like they had every right to be there. It didn't make sense. Land ownership in Colorado isn't vague. It's documented down to the inch. Property lines, plats, titles, everything is recorded. There's no gray area about who owns what. And according to every document I had, that land belonged to me. Still, something was clearly happening. Something big. That night, I spread every document I owned across my kitchen table. The original deed from my grandfather, the county plat maps, property tax records, survey reports from years ago. Everything matched. Parcel number 417B, 47 acres, owned by me. No easements, no shared access agreements, no development rights given to anyone. So how were dozens of workers building houses on it? The next morning I drove straight to the county clerk's office. Small government buildings always have the same atmosphere. Fluorescent lights, quiet hallways, people speaking in low voices behind glass windows. I waited in line holding my property folder, like it was evidence in a trial. When it was my turn, I slid the documents under the glass. "I need to check something," I told the clerk. "There's construction happening on my property." She typed my parcel number into the computer. For a moment, everything looked normal. She nodded as she scanned the screen. "Yes, this parcel is registered under your name." I felt a wave of relief. Then she kept scrolling. Her expression changed, not dramatically, just enough that I noticed. "Is something wrong?" I asked. She hesitated before answering. I asked, "Well, it appears there was a development proposal submitted for a nearby subdivision last year." "Nearby?" I asked. She turned the monitor slightly toward me. A digital map appeared on the screen. A digital map appeared on the screen. Colored boundary lines marked different parcels of land, and right in the center of the development plan was my property. Highlighted, divided, mapped out into neat rectangular lots, 96 of them. I leaned closer to the screen. "That's not nearby," I said slowly. "That's my land." She nodded carefully. "Yes, it appears the subdivision layout overlaps your parcel." Overlaps. That word didn't even begin to describe it. The map showed paved streets cutting straight through my forest, perfect rows of houses, cul-de-sacs, a clubhouse, even a small park drawn right over the creek I used to play in as a kid. It looked like someone had taken my land and erased it, replaced it with a neighborhood. "Who submitted this?" I asked. The clerk clicked through a few more pages. Development Group, Silver Ridge Communities. I'd never heard of them. "And this was approved." She nodded again. "Preliminary development approval last year. Final permitting earlier this spring." My mind struggled to process what she was saying. How does that happen without contacting the landowner? She paused. "Well, normally developers submit plats based on surveyed parcels. The county reviews zoning, utilities, environmental impact, but nobody checked who actually owned the land." She didn't answer directly. Instead, she printed a packet of documents and handed them to me. Subdivision layout, road access plans, utility grid proposals, architectural guidelines. The kind of paperwork you see when an entire neighborhood is about to be built. But every single page showed construction happening on property that legally belonged to me. I flipped through the packet. The streets already had names. Pine Hollow Lane, Aspen Ridge Drive, Grandview Court. Someone had planned every inch of it. 96 homes. And according to the permits, construction had already begun. I felt the same strange calm you sometimes feel right before something explodes. "Has anyone else questioned this?" I asked. She shook her head. "As far as the records show, no disputes have been filed." Of course not, because the one person who should have filed a dispute had no idea it was happening. I thanked her, gathered the paperwork, and walked out of the building. The sunlight outside felt harsher than before. I sat in my truck for a long moment, staring at the subdivision plans. That's when I noticed something strange. The developer documents never once listed my name. Not as an owner, not as a seller, not even as a neighboring property holder. Instead, the land was labeled as part of a larger parcel owned by something called Frontier Development Holdings. I checked the parcel number. It was one digit off from mine, 417D. Mine was 417B. Same road, adjacent land, completely different owner. But whoever filed the development plans had drawn the boundary lines wrong. Their subdivision map had spilled straight into my property like someone coloring outside the lines, and apparently nobody had noticed. Or worse, nobody had cared. I started my truck and drove straight back to the land. The closer I got, the louder the construction noise became. Nail guns popping, engines rumbling, trucks backing up with that constant beeping sound. When I reached the clearing again, the scale of the project looked even bigger than it had the day before. Bulldozers had carved wide dirt roads through the forest. Concrete foundations were already poured for several houses. Wooden frames were rising like skeletons across the hillside. Workers moved everywhere. Electricians, plumbers, surveyors, at least 50 people, all building a neighborhood on land they didn't own. I stepped out of my truck and walked toward the nearest construction trailer. Inside, a man in a reflective vest sat at a desk covered with blueprints. He looked up when I entered. "Can I help you?" I placed the county paperwork on his desk. "You're building houses on my land." He stared at me for a moment. Then he looked down at the papers, then back at me. "Who are you?" he asked. "My name is Daniel Carter," I said. "I own parcel 417B. He leaned back slowly in his chair. "Look," he said, "we're working under approved permits. I'm sure you are. But the permits are wrong." He didn't seem worried. Developers usually don't. They deal with permits and land issues all the time. "Sir," he said calmly, "this subdivision was approved months ago. Survey teams verified the property line." He opened the county plat map and pointed directly at the boundary. "No," I said, "they verified the wrong lines." He studied the map. Then his expression shifted slightly. Not panic, but uncertainty. Still, he shook his head. "That's something you'll have to take up with the county or the developer. We're just the construction team," which meant the real decision makers weren't here. They were somewhere else, signing contracts. "Nor and developer. We're somewhere else, signing contracts, selling homes, and probably advertising the neighborhood already." I stepped back outside. A crane lifted wooden trusses into place on one of the half-built houses. Workers shouted directions. Someone laughed. It looked like progress, like the beginning of a community. But standing there with the paperwork in my hands, I realized something else. This wasn't just a mistake. This was a massive financial operation already in motion. 96 homes, each probably selling for hundreds of thousands of dollars. Roads, utilities, construction contracts, millions, maybe tens of millions of dollars already invested. And all of it built on land they didn't own. I could have stopped it right there. Called the sheriff, filed an emergency injunction, shut the whole site down before another nail went into the ground. Legally, I had every right to FGAR. But as I stood there watching the neighborhood rise out of my grandfather's forest, another idea started forming. Because if 96 houses were already under construction, and if buyers were already signing contracts, then stopping the project now would only cost the developer a setback. Delays, permits, legal headaches. But letting them keep building, letting them finish, that would turn their mistake into something much bigger. Something they couldn't quietly fix. I looked around at the foundations already poured, the lumber stacked in piles, the roads cut deep into the land. And for the first time since discovering the construction, I smiled. Then I folded the paperwork, got back in my truck, and drove away. Because sometimes the best move in a fight is waiting until the other side finishes digging the hole. For the next few days, I did nothing. At least, that's what it looked like from the outside. The construction site stayed busy. Trucks kept arriving before sunrise. Workers poured concrete, raised frames, and ran utility lines across land that legally belonged to me. And I didn't stop them. But behind the scenes, I was starting to understand exactly what had happened. The first call I made was to a real estate attorney. His name was Mark Feldman, a quiet guy in his late 50s who had spent most of his career dealing with land disputes in Colorado. When I walked into his office and laid the subdivision plans across his desk, he stared at them for a long time without speaking. Then he asked one question. "They're already building?" "Yes." "How many homes?" 96. He leaned back slowly in his chair. "That's ambitious." I handed him the county plat map and pointed at the boundary lines. "This is my parcel," I said. 47 acres. 47 acres. He compared the maps side by side. The more he studied them, the more his eyebrows lifted. "Well," he finally said, "this is one of the biggest surveying mistakes I've ever seen." "Mistake? That's the polite word." He turned the papers toward me. "Look here. The subdivision map clearly showed the developer's parcel, 417 D's, sitting next to mine, but their survey lines extended far past their boundary, straight into my land, by nearly 30 acres. That meant more than half of their planned neighborhood wasn't actually theirs. "Did the county approve this?" he asked. He sighed. "That means nobody double-checked the original survey, against the deed records. So what happens now?" Mark folded his hands. "Legally, you own the land. Every structure built on it belongs to you unless there's a valid agreement saying otherwise." I let that sink in. Even if someone else built the houses, even then, I looked back down at the subdivision plans. 96 houses, streets, utility lines, sidewalks. "If I stop them now," I said, "what happens?" He answered immediately. "They halt construction. The developer sues the surveyor, the county reviews permits, and eventually they redesign the project." "How long does that take?" "Maybe a year, maybe 2. "And what do I get out of it?" Mark shrugged slightly. "Nothing, really. The construction stops. Your land stays undeveloped, and the developer walks away with a very expensive lesson. That didn't feel satisfying. Not after what I had seen on my grandfather's land. The bulldozers cutting down trees, the creek buried under gravel. Someone had turned a place full of memories into a blueprint for profit without even asking who owned it. I leaned forward. "What if I don't stop them?" Mark frowned. "What you mean? What if I let them keep building?" For the first time since I walked into his office, he looked genuinely surprised. "You'd be letting them invest millions of dollars into property they don't own." "Exactly." He stared at me for a moment. Then he slowly started to understand. "You're thinking about waiting." I nodded. "Until it's finished." Mark stood up and walked to the window, thinking. When he turned back, his voice had changed. More cautious now. "Daniel, if you do that, this could become a very big legal fight." "How big?" He gave a small laugh. "Let's just say 96 homeowners won't be happy to learn their houses sit on land owned by someone else." I thought about that. Rows of brand new home, and families moving in, mortgage contracts signed. All of it built on land the developer never had permission to use. "What would happen in court?" I asked. Mark sat back down. "Well, the developer would probably argue something called improvements made in good faith. Basically, they'd claim they'd built the houses believing they had the legal right to." "And do they?" He shook his head. "Not if your deed clearly shows the property lines. I slid the original deed across his desk. My grandfather's signature sat at the bottom. The same boundaries, the same boundaries, the same boundaries. Recorded years before the developer ever submitted their plans, Mark studied it carefully. Then he looked up. This is airtight, so the land is still mine. Absolutely. I sat back in my chair. Then I'm not stopping them. He watched me for a few seconds. You realize how unusual that decision is? I do. Most landowners would shut the project down immediately. Most landowners didn't watch their childhood forest get bulldozed without permission. He nodded slowly. Fair point. For the next hour we discussed strategy. Not confrontation, preparation. The first step was documenting everything, photos of the construction, drone footage showing exactly where the houses were being built, copies of every permit, map, and survey filed by the developer. If this ever reached court, the timeline would matter. Who approved what, when construction began, and whether anyone had noticed the boundary error. Before I left his office, Mark gave me one last warning. If you go forward with this plan, you cannot interfere with construction. I won't. No threats, no confrontations, no notices. Understood? Because the moment you alert them, they'll stop and try to fix it. And I want them to finish. He sighed again. I figured, over the next several weeks, to it. Neighborhood grew quickly. I visited the land often, usually parking far enough away that the workers didn't notice me. Each time I returned, there was more progress. Concrete sidewalks appeared. Wooden frames turned into finished walls. Roof shingles replaced exposed plywood. Roads were paved where dirt trails used to be. Street signs were installed. Pine Hollow Lane.
Aspen Ridge Drive.
Grandview Court. Seeing those names posted along roads cut through my grandfather's forest was surreal, like someone had erased the past and replaced it with a brochure for suburban life. But I kept watching and documenting. By the second month, real estate signs started appearing at the entrance of the development. Coming soon, Silver Ridge Estates. The marketing trailer was parked near the main road. One weekend I drove by and saw families walking through model homes, couples pointing at kitchens, kids running through empty living rooms. They had no idea. To them it looked like any other brand new neighborhood. I sat in my truck across the road and watched for a while. Part of me felt bad. Those people weren't responsible for the mistake. They were just buying houses. That the real responsibility belonged to the developer who had built an entire community without confirming who owned the land. One afternoon Mark called me. I did some digging, he said. Find anything interesting? Very. He explained that Silver Ridge Communities had already pre-sold more than half the houses in the development. Contracts signed, deposits paid, construction timelines scheduled. These homes are selling for around $700,000 each, he added. I did the math in my head. 96 homes, $700,000 each. That meant the developer expected to earn roughly $67 million from the project, all of it built partly on land they didn't own. When construction keeps moving, Mark said. They're moving fast, I replied. They usually do when they're selling pre-construction homes. Good. You sound very calm about this, he said. I'm patient, Mark chuckled quietly. Remind me never to be on the opposite side of a land dispute with you. By the third month, the neighborhood looked almost complete. Finished houses lined the streets. Lawns were planted. Streetlights were installed. Some homes even had furniture delivered. Move-in day was getting close, and still, no one had noticed the problem. Or if they had, they hadn't told anyone. One evening I stood at the edge of the property as the sun dropped behind the mountains. The rows of new houses glowed orange in the fading light. It looked peaceful, like a finished dream. But I knew something the developer didn't. Every driveway, Every mailbox, every mailbox, every mailbox, every front door that sat on land that still legally belonged to me. And when the time came to prove it, that peaceful neighborhood was going to become the center of a legal storm none of them saw coming. Construction on the neighborhood moved faster than I expected. Within a few months, the place barely looked like the forest I had grown up in. The bulldozers were gone, replaced by clean asphalt streets, trimmed lawns, and rows of identical houses stretching across the hillside. 96 homes. When the project first started, it had looked chaotic, dust, lumber piles, half-built frames. But now everything looked finished, organized, like it had always been there. Streetlights lit the roads at night. Mailboxes stood at the end of every driveway. The developer had even planted rows of young pine trees along the sidewalks, trying to recreate the forest they had cleared. Ironically, those new trees stood exactly where the original one had been. I kept visiting the area quietly, not as the owner, just as someone watching from the edge. The real estate signs had changed too. The original "Coming Soon" banners were gone. In their place were bright signs reading, "Move-in ready homes," and people were moving in ready homes. People were moving in ready. The first time I saw a moving truck pull into one of the houses, I felt something strange. It wasn't anger. A young couple stepped out of the truck while two movers carried boxes inside. The woman stood on the porch holding a small plant while looking around the neighborhood with the kind of excitement people have when they buy their first home. To them, this place represented stability, a future. They had no idea the ground under their house legally belonged to someone else. More families arrived over the next few weeks. Cars appeared in driveways. Kids rode bicycles along Pine Hollow Lane. Garages filled with furniture. Lights turned on in windows at night. A neighborhood had formed, but something else appeared around that same time. At the entrance of the development, a large stone sign was installed. Silver Ridge Estates. And right below it, in smaller letters, a private community. That phrase mattered, because a private community meant something specific. It meant a homeowners association, an HOA. A few days later I received confirmation of it, not from the developer, from my mailbox. When I opened the letter, I almost laughed. The envelope had the Silver Ridge Estates logo printed neatly in the corner. Inside was a formal notice. "Welcome to Silver Ridge Estates." The letter introduced the Homeowners Association, explaining the community guidelines, monthly fees, and property standards residents were expected to follow. But one sentence caught my attention immediately. All property owners within the boundaries of Silver Ridge Estates are required to comply with HOA regulations. Property owners? I read that line twice, because technically I was the largest property owner inside their boundaries. They just didn't realize it. The letter continued with several rules. Landscaping must be maintained according to community standards. Exterior paint colors must be approved. No unauthorized structures. No parking violations. And, of course, mandatory HOA dues. At the bottom of the letter was a reminder failure to comply could result in fines or legal enforcement. I set the letter down on my kitchen table and stared at it. Somehow, a homeowners association had formed inside a neighborhood that partially existed on land owned by someone who had never agreed to any of it, and now they were sending me rules. A week later, another letter arrived. This one wasn't welcoming. It was a notice. Apparently, someone from the HOA board had inspected the property and noticed undeveloped land within the community boundaries that didn't meet their landscaping standards. The letter politely but firmly requested that the owner bring the land into compliance, which meant cutting grass, clearing brush, and maintaining the forest according to HOA guidelines. They included a deadline, 30 days. If the issue wasn't addressed, fines would begin. That's when I realized something. They truly believed the land belonged to the development. No one had discovered the mistake. Not the HOA board, not the homeowners, not even the developer who built the place. As far as they knew, everything inside the neighborhood boundaries was part of the community, including my 47 acres. I drove out to the property the next morning. The neighborhood looked peaceful. Sprinklers watered freshly planted lawns. A dog barked somewhere in the distance. 2 kids rode scooters past a row of parked cars, but beyond the last row of houses, my land still stretched out exactly as it always had. Dense forest, tall grass, wild brush, untouched, except for the sections where construction had cut into it. I walked along the edge of the development, where the paved street ended and the trees began. According to the subdivision map, this area was supposed to be a park, but legally, it was still part of my parcel. I took a few photos for my records. Then I heard footsteps behind me. A man approached from one of the nearby houses. He looked friendly enough, mid-40s, wearing a polo shirt with the Silver Ridge Estates logo on it. "Hey there," he said. "Morning. I haven't seen you around before." "I live nearby," I replied. He nodded and gestured toward the forest. "You know this land is part of the HOA property, right?" I looked at the trees. "Is it?" "Yeah. It's supposed to be community green space eventually. The developer just hasn't finished landscaping it yet." I almost smiled. "Interesting." He extended his hand. "I'm Greg, by the way. HOA board. Daniel." We shook hands. Greg seemed proud of the neighborhood. "You should have seen this place 6 months ago," he said. "Just dirt and construction. Now it's turning into one of the nicest communities around here." "I can see that." He pointed toward the forest again. "The board's been talking about cleaning up this section, maybe building walking trails, picnic areas, on my land." "That sounds like a big project," I said. "Yeah, but it'll raise property values." He paused, then added casually, "Why rave? Of course, we'll have to enforce maintenance rules until then. The HOA can't have overgrown land sitting in the middle of the neighborhood." I remembered the letter sitting on my kitchen table, the 30-day deadline, the fines they planned to charge the owner. Greg checked his watch. "Well, I've got a meeting to get to. Nice meeting you, Daniel." "You too." He walked back toward the houses while I stayed there for a moment, looking at the trees. The situation had reached a strange point. Not only had a developer built 96 homes on land they didn't own, but the homeowners association inside that neighborhood had begun acting like they controlled it too, sending letters, issuing warnings, threatening fines, all directed at the one person who actually owned the property. Later that afternoon, I called Mark. "You are not going to believe what just happened," I told him. When I finished explaining the HOA letters, he burst out laughing. "Rick, they fined you?" "Not yet, but they plan to." "That's incredible." "Is it legal?" "Not even close, but they think it is." "Not even close, but they think it is." Mark paused for a moment. "You kept the letters, right?" "Of course." "Good. Every piece of communication like that helps." "Helps with what?" "With showing how deeply the mistake has spread." He was right. The developer had made the original error, but now the entire neighborhood structure, the HOA, the homeowners, the community itself, was operating under the assumption that the land belonged to them, which meant when the truth finally came out, it wouldn't just shock the developer, it would shock everyone. And the bigger the neighborhood became, the harder it would be for them to undo it. That night I stood on a hill overlooking the development. Lights glowed from dozens of houses. Cars lined the streets. People walked dogs along sidewalks that had been paved over what used to be forest trails. It looked permanent, like it had been there for years, but legally, every one of those homes sat on a foundation, built partly on land owned by someone they had never met, and soon they were all going to find out. By the time Autumn arrived. Silver Ridge Estates looked like it had been there for years. The streets were fully paved. Every house had finished landscaping. Trees lined the sidewalks, and freshly planted grass had already begun to thicken into neat green lawns. At night, warm light spilled from the windows of nearly every home. Cars filled the driveways. Children waited for school buses at the corners. Neighbors waved to each other while walking dogs down Aspen Ridge Drive. If someone had driven through the neighborhood without knowing its history, they would have assumed it was just another successful suburban development outside Boulder. But I knew something no one else in that neighborhood knew. Every time I drove past the entrance sign, Silver Ridge Estates, a private community, I couldn't help thinking about how fragile the entire place actually was, because the legal foundation of that entire community didn't exist. And the longer it operated like everything was normal, the bigger the consequences were going to be. The HOA letters didn't stop either. A month after the first notice, another envelope arrived in my mailbox. This one was less polite. Second notice, landscaping violation. According to the letter, the undeveloped section of land inside the neighborhood still failed to meet community standards. The HOA board had conducted another inspection and determined that the property owner had ignored their first request. As a result, they were issuing a fine, $200. If the issue wasn't corrected within 2 weeks, additional fines would follow. I set the letter next to the first one and looked at them both. $200 for failing to maintain land that legally belonged to me in a neighborhood that technically shouldn't exist. Later that week, I received a third letter. This one came from a law office representing the HOA. The tone had shifted again. The lawyer explained that continued non-compliance could result in legal action to enforce community standards, including liens against the property. A lien, a homeowners association built inside a subdivision that partially sat on my land, was threatening to place a lien against that same land. The irony was almost impressive. I called Mark that afternoon and read the letter to him over the phone. When I finished, he was quiet for a moment. "Please tell me you kept every envelope," he said. "Of course." Good. Is this as ridiculous as it sounds?" "Even more so," he replied. "They're attempting to enforce authority over property they have absolutely no legal control over. So what do we do?" "Nothing yet." That answer didn't surprise me anymore. Waiting had become part of the strategy. The longer the neighborhood functioned as if it owned my land, the stronger our position would become when everything finally came to light. But something else happened around that time that made the situation even bigger. One afternoon, while driving past the development, I noticed a row of new banners hanging near the entrance. "Phase 2, coming soon." I slowed the truck and stared at the sign. Phase 2. That meant the developer planned to expand the neighborhood even further. I pulled into a small gravel turnout across the road and watched the construction area for a few minutes. A sales trailer had been set up again, this time advertising future homes that hadn't even been built yet. Apparently, Silver Ridge Estates had been successful enough that the developer wanted to grow it. The problem was, the only direction left for expansion was deeper into my land. That evening, I met Mark at his office. I showed him photos of the Phase 2 banners. He leaned back in his chair and shook his head, slow, wily. "They still haven't discovered the boundary issue." "Apparently not, and now they're planning to expand." "Looks like it." Mark rubbed his temples, like someone trying to process something absurd. "Daniel, this situation is becoming extraordinary." "How so?" "Well, originally we were dealing with a developer building part of a neighborhood on land they didn't own. And now? Now we're looking at a fully occupied subdivision, an active homeowners association, and future expansion plans, all based on incorrect property boundaries." I leaned forward. "So when we finally address it, it won't just affect the developer," he said. "It'll affect everyone." That part had been in the back of my mind for months. Families were living in those homes now. People had invested their life savings into those houses. Mortgage contracts had been signed. Banks had financed loans. Real estate agents had sold properties, and yet none of them realized the land situation. But legally, responsibility didn't fall on the homeowners. It fell on the developer who had built the project, and the surveyors who had mapped it, and the county officials who had approved it without checking the records properly. Still, the reality of what was coming was enormous. "Are we ready?" I asked. Mark opened a folder on his desk. Inside were copies of everything we had been collecting for months. County records, survey reports, photographs of construction from beginning to completion, HOA letters, property tax documents, and the original deed from my grandfather. "Yes," he said quietly, "we're ready." But before anything moved forward, one final thing happened. About 2 weeks later, I received another letter from the HOA attorney. This one wasn't a warning. It was a formal demand. The letter stated that because the property owner had continued ignoring HOA regulations, the association would begin legal proceedings to enforce compliance. They planned to seek court authorization to maintain the land themselves and charge the costs to the property owner. In other words, they were about to file a lawsuit against me. I drove straight to Mark's office with the letter. When he finished reading it, he leaned back and let out a long breath. When he finished reading it, he leaned back and let out a long breath. "Well," he said. "What? They just made the first move. And that's bad." He smiled slightly. "Not at all. In fact, it was exactly what we needed. Because once a case entered the court system, every document related to the land would be examined. Property boundaries, ownership records, subdivision approvals, everything. Which meant the truth about Silver Ridge Estates would finally come out. Not quietly, not privately, but in a courtroom." Mark folded the letter and placed it on top of the file. "Daniel," he said, "how attached are you to that land emotionally?" I thought about my grandfather, the summers in the forest, the creek running through the trees. "I care about it," I said. "Why?" "Because there's a chance this situation could end in several ways." "Like what?" "The developer might offer to buy the land. And if they don't, then the court will have to decide what happens to 96 houses built on property owned by someone else." The weight of that sentence hung in the room for a moment. 96 houses, families, mortgages, an entire neighborhood, all sitting on land whose owner had never agreed to any of it. Mark closed the folder. "Either way," he said, "this is going to be one of the most interesting property cases this county has ever seen. And for the first time since discovering the construction months earlier, the moment of truth was finally approaching." The lawsuit arrived exactly 2 weeks later. A courier delivered the documents to my house early on a Tuesday morning. The envelope was thick, stamped with the official seal of the county court. Inside were pages of legal language outlining the HOA's complaint. They claimed the owner of the undeveloped land within Silver Ridge Estates had violated community rules by refusing to maintain the property according to HOA standards. They were asking the court for enforcement authority, permission to access the land, permission to clean it up, permission to bill the owner for the cost. And if those costs weren't paid, they wanted the court to approve a lien. All of it was written with complete confidence. Whoever drafted the complaint clearly believed the HOA had jurisdiction over the land. They believed the neighborhood owned everything inside its boundaries. They believed the owner of the forested land was just another resident, refusing to follow the rules. They had no idea what they had just stepped into. I drove to Mark's office with the lawsuit that same afternoon. He read through the complaint slowly, occasionally shaking his head. When he finished, he placed the stack of papers down and looked at me. "This simplifies things." "How?" "Why? Because now we don't have to initiate anything. They already did." I sat across from his desk. So what happens next? We respond. Mark opened the large case file we had been building for months. Every document inside represented a piece of the puzzle. The original deed, county parcel records, tax documents showing the property had always been registered under my name, survey maps proving the subdivision boundaries were incorrect, photographs showing construction spreading across my parcel, HOA letters demanding compliance, the entire timeline, everything the court would need to see. But one document mattered more than all the others. The deed, signed by my grandfather, recorded years before the developer even submitted their plans. Mark held it carefully. "This," he said, tapping the paper, "is the foundation of the entire case, because it proves ownership." Exactly. A few days later, Mark filed our response with the court. The HOA expected a defense. Maybe a negotiation, maybe an argument about landscaping. What they got instead was a legal bombshell. Our response didn't just deny the HOA's authority. It explained why the HOA had no authority at all. Because the land they were trying to regulate didn't belong to the neighborhood. It belonged to me, and it had never been sold, transferred, or included in the development. Attached to the filing were copies of the property records, the subdivision maps, and a formal statement pointing out the boundary error. The developer's parcel, 417D, ended far earlier than their subdivision map claimed. Everything beyond that line belonged to parcel 417B, my parcel, which meant something very simple. A large portion of Silver Ridge Estates had been built on land owned by someone else. The court scheduled the first hearing 3 weeks later. In that time, something interesting happened. The developer finally noticed. Mark called me one morning, sounding almost amused. "Silver Ridge Communities just contacted me." That didn't take long. They received notice of the case, and they want to talk. Of course they did. Up until now, the HOA had been operating independently. They were just trying to enforce neighborhood rules, but once the court filing mentioned property ownership and boundary disputes, the developer would have realized the scale of the problem. They had built 96 homes, sold most of them, and now a lawsuit had appeared claiming the land underneath part of those homes wasn't theirs to build on. That kind of discovery, too, ends to get attention. A meeting was arranged for later that week. The developer's representatives arrived at Mark's office exactly on time. 2 lawyers and a man in his early 40s who introduced himself as Kevin Mercer, vice president of Silver Ridge Communities. He looked calm when he walked in, professional, confident, but that confidence faded quickly once the documents came out. Mark placed the deed on the table first, then the county parcel map, then the subdivision plan. Kevin studied them quietly. "You're saying our development crossed this boundary?" he asked. "Yes," Mark replied. "By how much?" "Roughly 30 acres. Kevin blinked. "That's impossible." Mark slid the survey comparison across the table. The lines made it obvious. The developer's survey had extended far past the legal boundary. Kevin leaned back slowly. His lawyers were already whispering to each other. "This development went through county approval," he said. "That doesn't change property ownership," Mark replied calmly. Kevin looked at me for the first time. "You're the landowner?" "Yes." "And you've known about this for how long?" "Since construction started." The room went quiet. "Since construction started." The room went quiet. Kevin stared at me. "You watched us build the entire neighborhood?" "Yes." One of the lawyers cleared his throat. "This could have been addressed earlier." "This could have been addressed earlier?" "It could have," Mark said. "But the landowner had no legal obligation to correct the developer's mistake." Kevin ran a hand through his hair. "You realize what this means?" "Yes," Mark said. "It means dozens of homes are partially built on land that doesn't belong to the developer." Kevin's voice dropped. "Do the homeowners know?" "Not yet." That answer made the tension in the room even heavier. because everyone there understood the same thing. If the homeowners found out before the developer solved the probe, then the entire situation could spiral into chaos. Mortgage lenders, title insurance companies, property disputes, potential lawsuits from buyers. All of it triggered by one surveying mistake. Kevin turned back to me. "What do you want?" he asked. It was the first honest question of the meeting. "What do you mean? You own the land. So what's your goal here?" I looked at the maps spread across the table. Rows of houses, roads cutting through forest that had once belonged to my grandfather. "What do you think my goal is?" I asked. Ever Kevin didn't answer, because he already knew. The meeting ended without a deal. The developer needed time to assess the situation, their lawyers needed to review the records, and the court hearing was approaching fast. When Kevin left the office, his calm confidence from earlier was gone. He understood now. Silver Ridge Estates wasn't just a successful neighborhood anymore. It was a legal disaster waiting to unfold. And the next time we all saw each other would be inside a courtroom, where one piece of paper, the original deed, was about to change everything. The courtroom was quieter than I expected. Property disputes rarely attract crowds, but this case had started drawing attention the moment the filings became public record. By the time the hearing date arrived, several reporters had already begun asking questions about Silver Ridge Estates, 96 homes, a fully occupied neighborhood, and a claim that a large portion of it sat on land owned by someone else. That kind of situation doesn't stay quiet for long. When I walked into the courthouse that morning with Mark, the hallway outside the courtroom was already filled with people. Some of them were homeowners from the neighborhood. You could recognize them easily. They stood in small groups, whispering nervously, holding folders of documents or printed emails. A few of them looked confused more than anything else, because up until recently, most of them had no idea anything was wrong. The developer's representatives were there too. Kevin Mercer stood near the back of the hallway with his lawyers, speaking in low voices. When he noticed me walking in, he nodded politely, but the tension in his face hadn't disappeared since our last meeting. This case had grown far beyond a simple HOA dispute. Now it was about property ownership, and that meant the court would have to look at one thing that matters most in land law: the deed. When the courtroom doors opened, everyone filed inside. The judge entered a few minutes later, and the room settled into silence. The case was called. The HOA attorney spoke first. He stood confidently and began explaining the original complaint. According to him, the Homeowners Association had attempted to enforce landscaping standards on property located within the boundaries of Silver Ridge Estates. The property owner, he said, had ignored repeated notices. The HOA had no choice but to seek court enforcement. From his perspective, the issue was straightforward: an owner refusing to follow community rules. But that explanation only lasted a few minutes, because when Mark stood up to respond, the entire tone of the courtroom changed. He started calmly. "The honor the Homeowners Association believes it is enforcing rules within its community boundaries. Unfortunately, those boundaries are incorrect." He walked to the evidence table and picked up the first document, the county parcel map. This map shows the legally recorded parcels for the area in question. He placed it in front of the judge. Parcel 417. D belongs to the developer responsible for Silver Ridge Estates. Then he lifted the second document. The neighboring parcel 417B is owned by my client. Next came the third document, the subdivision plan submitted by the developer. This plan, Mark continued, shows the layout of 96 homes built by the developer. However, as the court can see, he pointed to the overlapping lines. And the subdivision extends well beyond the boundary of parcel 417D. The judge leaned forward slightly, studying the map. Mark's voice remained steady. In fact, Approximately 30 acres of the development were built on parcel 417B. The room behind us shifted. A ripple of whispers moved through. A ripple of whispers moved through. The seats where the homeowners were sitting. The judge looked up. "And who owns parcel 417B?" he asked. Mark turned toward me, my client. The judge raised an eyebrow. "And how long has he owned it?" Mark lifted the final document. The deed, binding. The deed, signed, recorded, legally binding. This deed was recorded years before the subdivision plans were ever submitted. He handed it to the clerk, who passed it to the judge. The judge read it carefully. Then he compared it to the parcel map, then to the subdivision plan. The silence in the courtroom stretched longer than anyone expected. Finally, the judge looked toward the developer's legal team. "Counsel," he said, "are you disputing this deed?" The developer's lawyer stood slowly. "No, Your Honor." "Are you disputing the parcel boundaries reported by the county?" "No." "Then, is there any legal document transferring ownership of parcel 417B to your client?" The lawyer hesitated. "No, Your Honor." Hesitated. "No, Your Honor." That answer settled the most important question in the entire case. Ownership. The judge leaned back in his chair. "So, let me understand this clearly," he said. A residential development was constructed, partially on land owned by someone who never sold it, leased it, or granted permission to use it. The developer's lawyer nodded carefully. "Yes, Your Honor, and the Homeowners Association is attempting to enforce regulations on that same land. Yes." The judge looked down at the deed again, then back at the courtroom. "Well," he said quietly, "that presents a rather significant problem." Behind us, the homeowners had stopped whispering. They were listening now, because the reality of what was happening was starting to sink in. One woman stood up from the audience. "Your Honor," she said nervously, "does this mean our houses?" The judge gently raised a hand. "I understand there are many concerns," he said, "but today's hearing is focused on property ownership and the authority of the Homeowners Association." He turned back toward Mark. "Counsel, what exactly is your client seeking?" Mark didn't hesitate. "For now, Your Honor, we are simply asking the court to recognize the ownership of parcel 417B and confirm that the Homeowners Association has no legal authority over it." The judge nodded slowly. "That seems straightforward." He turned toward the HO attorney. "Given the documents presented today, it appears the association's complaint was filed under the assumption that this land was part of the subdivision." The attorney cleared his throat. "That was our understanding, Your Honor, and that understanding appears to have been incorrect." "Yes." The judge placed the deed on the bench. "In that case, the court finds that parcel 417B remains the legal property of the defendant." A quiet wave of reactions moved through the courtroom. The judge continued. "The Homeowners Association has no jurisdiction over property. It does not own or control. Therefore, the complaint is dismissed." Just like that, the lawsuit was over. But the real consequences were only beginning, because now the court had officially confirmed something that everyone in the room understood. A large portion of Silver Ridge Estates sat on land owned by someone else. The judge looked toward the developer's lawyers one last time. "I strongly suggest all parties involved address the larger property issues immediately," he said. Then he struck the gavel. The hearing was adjourned. When people began filing out of the courtroom, the tension in the hallway was completely different from earlier that morning. Homeowners surrounded the developer's lawyers with questions. Some looked confused. Others looked angry. Kevin Mercer stood near the wall, staring at the floor like someone replaying every decision that had led to this moment. He finally approached me as I stepped outside. "I guess the deed speaks for itself," he said quietly. "It usually does," he nodded slowly. "So now what? I looked out toward the street for a moment before answering. That depends, I said. On what? On how much 96 houses are worth to you. Kevin didn't respond immediately. But he didn't need to, because everyone involved in the situation now understood the same thing. The houses might belong to the homeowners, but the land beneath them still belonged to me.